to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing.
All right, guys, this one is a little different. Today we've got a sovereign citizen who absolutely refuses to stop talking and clearly believes the rules don't apply to her. Throughout the hearing, she keeps interrupting the judge and arguing with officers as if volume and repetition are somehow going to win the case. Spoiler alert, that strategy does not work. What makes this one stand out is the judge's response. He's completely no-nonsense, calm, firm, and clearly not interested in entertaining speeches that have nothing to do with the actual charges. The more she talks over him, the more you can see where this is headed. And by the end, the sentence definitely catches her off guard. This hearing is a perfect example of how courtroom behavior matters. Confidence without legal footing doesn't move the needle, it just accelerates the outcome. As you watch, pay attention to how the dynamic shifts. Do you think the judge handled it fairly, or did he come down too hard? Drop your thoughts in the comments, and let's dive in.
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacks jurisdiction over the subject matter.
What is your date of birth?
The court lacks jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacks jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. It's the judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. Turn it on.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now. Turn it on.
Yes, it is, Justin.
All right.
This is what it looks like when someone who believes they're above the rules runs straight into reality. From the way she's acting, it's clear she sees herself as the victim in this situation. But walking into court and immediately talking over the judge? That's not confidence. That's a misunderstanding of how serious the setting is. Courtrooms operate on structure and respect. Interrupting the judge, raising your voice, and refusing to engage with the actual legal issues doesn't strengthen your case, it weakens it. Especially when you're facing significant time. That's not the moment to test boundaries. And here's the thing. People don't just wake up one day and decide the law doesn't apply to them. These beliefs usually build over time. But regardless of how someone arrived at that mindset, the courtroom isn't going to validate it. The law isn't flexible based on personal conviction. At the end of the day, it comes down to accountability. You can argue philosophy all day long, but once you're standing before a judge, the only thing that matters is how your actions align with the law. What do you think? Is this genuine belief, or just refusal to accept consequences?
So the offenses are non-dangerous. I'm finding them
Why you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count... Count 4, Your Honor. The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up? You're not? Okay.
Because I don't want to be in here.
Stay in.
To leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No,
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not have no right, get this shit off of me.
At this point, the situation has clearly escalated. When someone ends up restrained in a courtroom, that's not random. That's the result of behavior crossing a line. Courts don't take those steps lightly. What really stands out here is how much disruption this caused. Multiple officers had to step in just to manage one defendant. That's a significant allocation of resources for a single hearing. While this is unfolding, other calls and responsibilities are still happening across the city. Court security isn't entertainment, it's about maintaining order. And here's the bigger issue. When someone keeps escalating instead of complying, it only compounds the consequences. The courtroom isn't a stage for grand statements. Once safety becomes a concern, control takes priority over debate. You can also see it on the officers' faces. They're not reacting emotionally. They're just doing their jobs. Calm, procedural, and focused on keeping the environment stable. The real takeaway here isn't drama, it's cause and effect. Disruptive behavior leads to intervention. Intervention leads to stricter outcomes. What do you think? Did this situation spiral because of stubbornness, or was it inevitable from the start?
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-707?
Yes, I'm sorry, ARS 13708.
It's illegal.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender, with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5.
If you're enjoying the breakdown, make sure to like and subscribe. It really helps support the channel. Now let's get back to the case.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for her arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the costs of an attorney to represent you on appeal. That will include the costs of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did he give you? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you all.
At this point, sovereign citizen hearings almost aren't surprising anymore. It feels like every week there's another video of someone arguing maritime law in a traffic case and insisting the court has no authority, right before the handcuffs come out. What stands out isn't just the arguments themselves, but how consistently they fail. Courts across the country have repeatedly ruled that claims of diplomatic immunity, strawman theories, or simply rejecting citizenship have no legal standing. These arguments have been tested over and over, and they collapse every single time. The pattern is predictable. Someone believes they've discovered a loophole the legal system somehow missed. They walk into court confident. They deliver a long speech. And then reality sets in when the judge applies actual statutes and precedent. It's almost like watching someone try to use a Monopoly get-out-of-jail-free card in real life. Creative, maybe. Legally effective. Not even close. The courtroom isn't built on internet theories. It's built on codified law. And no matter how passionately someone argues otherwise, that structure doesn't change. This one was intense, though. The level of disruption and confidence in arguments that have already been rejected so many times was something else. What do you think? Are these defendants genuinely convinced, or are they just hoping persistence will somehow override the law? Drop your thoughts in the comments. I always appreciate hearing your perspective. Take care, and I'll see you in the next one.